and welcome our guests, Josh Blackman and Ilya Shapiro. My association with Ilya and Josh began last November when, through our executive editor, Frederick Richardson, they approached us and said, hey, could you publish this article about the Privileges or Immunities Clause in McDonald v. Chicago? And just based on who it was that was submitting the article and what it was about, we took it sight unseen, and gosh, that was probably the smartest thing that we've done all year. It's a very powerful article, and I don't think as far as a law review article goes, you could have a more timely and important article than what they gave us. So thank you for submitting that to us. Before I turn it over to our guests, just a few quick words of introduction about both of them. Ilya Shapiro is a senior fellow in constitutional studies at the Cato Institute, and he's editor-in-chief of the annual Cato Supreme Court Review. He's also an adjunct professor at the George Washington University Law School, a prolific author with numerous works in both the legal and mainstream press, and a regular television and radio personality, commenting on legal and political issues with outlets as wide-ranging as Fox News to American public media. Ilya's diverse experience includes a federal clerkship, extensive private practice experience here in D.C., and service as a rule of law advisor to multinational Force Iraq. He's a graduate of the University of Chicago Law School. Josh is co-founder and president of the Harlan Institute for Constitutional Studies and is currently a law clerk for the Honorable Kim Gibson of the U.S. District Court for the Western District of Pennsylvania. He's also a prolific author. Only 1 year out of law school, he's published 5 law review articles, and he co-teaches a class in federal courts practice at Penn State's Dickinson School of Law. He may be best known to this audience for his blogging exploits, cited today in the New York Times as the czar of fantasy SCOTUS. He also is a regular contributor to Above the Law. He contributes to numerous other blogs, and he has his own site, joshblackman.com, which is being livecast, which this presentation is being livecast on today. Josh is a graduate of the George Mason University School of Law. Please welcome me in joining Ilya and Josh.
Well, thanks very much. If any of you are here just because you care about guns, which I guess is less in D.C. when I've done these presentations, all different parts of the country, that tends to be more of the case. But if all you're caring about is the Second Amendment and your gun rights and whether you can, you're coming from Virginia, you're coming from wherever it is you're coming from to go to Georgetown, and you want to know whether you can bring your gun and things like that, the answer is yes. So you don't really have to, if that's all you care about, then the presentation is pretty much over, and the rest of it might not be as interesting to you. But really, it's fascinating that this is even, that we're even talking about guns or the Second Amendment or the right to keep and bear arms, because if you think about it, 10 years ago, 15 years ago, if you'd asked anyone in the conservative or libertarian or progressive movements whether privileges or immunities, slaughterhouse, these types of things would be revisited in the Supreme Court, what kind of case would that take? And our whole incorporation doctrine, how does the Bill of Rights or the rights contained therein, or natural rights, how do they apply to the states? That whole body of jurisprudence, how will that ever be revisited or reconsidered or fundamentally rethought in the Supreme Court? Nobody from any ideological persuasion or professional persuasion, be it from legal scholars to reporters, would tell you that, oh yes, I think it's going to be through a gun case. Nevertheless, here we are. And after District of Columbia versus Heller, which of course
we have a very special guest.
Alan Gore argued, and won successfully a couple of years ago, and an alumnus of Georgetown University Law Center, indeed. At that time, the court ruled that the Second Amendment was an individual right to keep and bear arms. But that only applied to D.C., and it was specifically chosen by Alan and Clark Neely and Bob Levy, my boss, the chairman of Cato, for that reason. And so we have this secondary wave of litigation about what that means for the states, where, after all, most people live. for their good judgment, most people don't, like myself, live in the District of Columbia. I actually live 3 blocks about down that way. And that question is a fairly, the result is a very simple one. All of the Bill of Rights, save whether you have a right to indictment by grand jury and a civil trial for, a jury trial for civil cases over $20 and unanimous jury, things like that, very small parts of the Sixth Amendment, that's all been incorporated. It's pretty certain the Second Amendment will be as well applied to the states. But the question is, and this is why it's crucial that the the cert petition that the Supreme Court granted was Allen's rather than the NRA's, because the McDonald petitioners asked whether the right to keep and bear arms would be applied to the states via the Due Process Clause or the Privileged Immunities Clause of the 14th Amendment. That's an important question. It's not just for legal wonks, we want to get our law exactly right. I mean, who cares, right? Your gun rights are extended. Well, it matters because if you do it the right way constitutionally, staying more true to the original public meaning of the Constitution, that prevents and forestalls judicial activism, judges reading into the 14th Amendment or the Bill of Rights or whatever you're concerned about, things that shouldn't be there. It also provides the opportunity for restoring a lot of the protections that have been destroyed over the years by jurisprudence that, for example, bifurcates our rights into fundamental and something less than fundamental. I'm referring to Caroline Products, footnote 4, and other such issues. The problem is, though, when you get into privileges or immunities, that's been dormant. Indeed, it's been dead since 1873, when 5 years after the ratification of the 14th Amendment, the court in the slaughterhouse cases said that that clause protects, protection against states infringing your rights on the high seas, or the right to visit the Bureau of Engraving and Printing and federal sub-treasuries and so forth. I mean, those aren't the types of rights that I think about. And I should add, I'm not a citizen, so perhaps this applies differently to me. But even as a non-citizen, one of the primary things that I care about is not, Arkansas violating my rights on the high seas, or New Mexico preventing my access to some sub-treasury in Albuquerque, where I was last week. But the problem is, this privileged immunity is, okay, so we're asking the court to reconsider slaughterhouse. Well, does that not open a Pandora's box of problems that could issue from there? And that's where the article that Josh and I have co-authored comes from in the Georgetown Journal of Law and Public Policy. And wherever you stand in ideologically, jurisprudentially, you have some concerns about this, because if you have this blank slate, this newly revised Privileges or Immunities Clause that hasn't been treated with seriously since 1873, well, the progressives will read in their rights to health care and welfare and education and what have you, and all of these positive rights. And, well, the libertarians, coming from the progressive perspective, will read in these terrible rights to the right to earn an honest living and contract and property rights and all of these things, which will strike down the health and safety regulations and licensing laws. State bar associations might not be able to prevent people from writing simple wills and trust documents without having gone through 3 years of law school and taking a rigorous bar exam and all of these things. I mean, that's terrible. And from the conservative perspective, I mean, the court might be upholding through this new fangled Privileges or Immunities Clause the right of polygamous same-sex midget marriages to smoke pot in post offices. I mean, it's terrible. It's crazy. So people are wary about this. And hence, Josh and I wrote this article to assuage and mollify the concerns about this potential Pandora's box. Because while there is a large scholarly consensus that slaughterhouse was wrongly decided, and I mean this isn't a a spin doctoring. I mean, you had a brief in this case signed by everyone from Jack Balkin to Steve Calabrese. Jack Balkin's a liberal Yale law professor, to Steve Calabrese, one of the co-founders of the Federalist Society at Northwestern, and Randy Barnett, one of the preeminent libertarian legal scholars, and a bunch of other people, all saying slaughterhouse is wrong, privileges or immunities actually has some substance to it. So beyond that, Josh and I wanted to tell the court and conservatives and libertarians who were concerned about these things that it actually doesn't open a Pandora's box, and that indeed it's better to use this. It's easier to stay faithful to the Constitution than to push further substantive due process, which has been abused and warped to the point where that is the part of the Constitution that judges have used to read in their policy conclusions. And so I'll let Josh talk about the actual substance and law of our article, and I'll come back later and talk about the case precisely at hand and how things will go from here.
All right, thanks, Ilya, and thanks again to everyone at Georgetown and the Georgetown GOPP. You've been fantastic, and they got this article printed, I'm not kidding, in like a month. We gave them the draft in a month, it was in our hands, and that was absolutely fantastic, and I really hope it makes a difference in the arguments. Now, I am personally wedded in this case because I spent the last 18 hours of my life on the streets outside of 1 First Street, and I froze my butt off all night just so I'd be sure to get my spot in arguments. So this is something that's very important to me. And I'd like to begin with a quote today, which Mr. Gurr might quiver at, but I think he'll chuckle. Justice Scalia today quipped, "Unless you are bucking for a place in the law school faculty and aim to be a darling of the professoriate, why would you undertake to overturn 140 years of precedent?" Sigh. Well, I think Justice Scalia is misguided. Precedent is not some kind of free-flowing thing that you follow simply because it's precedent. You follow it when it's right, and if it's wrong, and especially if it's constitutional law, the decisive value is much weaker. So when Justice Scalia asked Attorney Gurr this question, I think he had a very good response. But the thing that is most important to remember is what we are doing is we are enacting the meaning of the Privilege of Immunities Clause. The 14th Amendment changed a lot of things. It really radically reconstructed how our country was shaped and how the states can no longer abridge certain rights that people held. For a justice to say, well, stare decisis, we have to follow this precedent, period, that kind of ignores the struggles that went into the 14th Amendment. This ignores the rights, the philosophy, the things they aim to do. And if the Supreme Court are actually originalists, and they are people who want to protect liberty, this stare decisis should not be the biggest barrier, because as Ilya mentioned, this case is not about guns. This case is about liberty. Put yourself back in the mindset of a freedman in the 1860s. You just fought the Civil War. You just got your freedom. You're no longer a slave. And you have the marauding Ku Klux Klan going through the hills of the South. And then lynching people, taking them away. You have no way to protect yourselves. One of the most important things that the radical Republicans gave these freedmen was the right to bear arms. They said, you have this right. You can protect yourself. When you have these state-run lynch mobs, the state cannot disarm you. This was a very important way of people to defend themselves. And this is something that is so important. Now, if the Privilege of Immunities Clause protects this right, then I think it's a very good way that we can actually have an incorporation of the Second Amendment. Now, to go a little bit more, I'll come back to my observation of the arguments in a bit. I'll just give you an idea in a nutshell of how this works. Privileges and immunities is actually kind of a term of art. This is not some sort of free-flowing font of rights that you can pull out of thin air. In the 1860s, this had a very well-established public meaning. And Dave Harding did a very good article in Whittier Law Review very recently, looking at newspaper articles saying, what do these terms mean? So what were these privileges or immunities? The privileges and immunities were certain rights that were held by the people, that included both more and less than those in the Bill of Rights. This included not only the certain protections that you held in the Bill of Rights, but certain unenumerated protections. Among these...
That's a term that Akil Amar has used at Yale, both more and less than the Bill of Rights. So again, we're presenting something, we'll let you know when we're presenting something that's controversial. Most of this is accepted scholarship that we're trying to sharpen for this particular case.
Absolutely. This is from Akil Amar's book, The American Constitution Biography. It's actually a pretty good book. And Professor Amar explains that the privileges and immunities include both more and less than those rights in the Bill of Rights. Now, what do you mean less than those in the Bill of Rights? Well, there's certain provisions in the Bill of Rights that are federalism provisions. For example, the Establishment Clause. It's a federalism provision which says the federal government can't prevent the states from doing certain things. The 9th and 10th Amendment, for example, those are federalism provisions. They place limitations on the federal government. But what's more than the Bill of Rights? And this is one of the points that was very acute during oral arguments today, where Justice Ginsburg and Justice Kennedy repeatedly asked, what are these unenumerated rights? I think Attorney Gurr very ably pointed to certain statutes like the Civil Rights Act of 1866. What the Civil Rights of 1866 Act did was to give certain rights to the freedmen. Among these were these rights to property, the rights to sue and be sued, the right to give testimony, and perhaps most importantly in this case, the right to bear arms. These are very important indicia of what this right meant in the 1860s. And these are very important ways to understand what the privileges and immunities of citizenship are. So now that you actually have an idea of what the Privileges and Immunities Clause are, let's take a step back and go to incorporation for the Due Process Clause. As I'm sure you all know, and just, you know, Ilya's telling me to slow down. And when I get excited, I talk really quick. And as you know, I'm very excited about this case because I was at the Supreme Court all night and I'm going like maybe 2 hours of sleep. So I'm going to do my best to slow down.
I try to match him by drinking about a bottle and a half of wine at lunch, so...
We can just stand up later if you like. Anyway, so what happens is, as the 14th Amendment was written, at the time of the founding, the Bill of Rights did not apply to the states. You know, Barron v. Baltimore said the protections of the Bill of Rights only applied to the federal government. But the 14th Amendment changed things. But how did it change things? Did it change things through the Due Process Clause or through the Privileges and Immunities Clause? Through various techniques, the Supreme Court has actually used the Due Process Clause to basically incorporate or extend certain protections to the states. But there's an alternative theory, and one which Professor Marr, Professor Barnett, and a lot of other prominent scholars have identified, that the Privileges and Immunities Clause was actually meant to extend rights to the states. Now the addition that Ilya and I make to this is that we don't see it as a mere injection of the federal right from the Constitution to the from the federal Constitution to the state Constitution. What it's actually inserting is the understanding of these rights as they exist in 1868. So what the court actually should do in this case is not merely incorporate the Second Amendment as it's written in 1791. What they should actually be doing is extending the right to keep and bear arms for defense of person and property as it was understood in 1868. And this in many senses is an even broader right. It's a right which protects you to, it's not a right to make sure that the British people don't disarm the colonists, it's a right to make sure that people can protect their homes, their families, from intruders, from invaders. In those days it was a clan, but today it could be a burglar. Justice Breyer's favorite example, the shooting the burglar exception to the Second Amendment. You mentioned that one a couple of times. And that's kind of what we're arguing the Privileges and Immunities Clause should do. And
so it's along with this more and less than the Bill of Rights is the idea that the Privileges or Immunities Clause is freestanding. It doesn't incorporate the Second Amendment. It applies the right to keep and bear arms, about which the Second Amendment is persuasive evidence, and other evidence is also persuasive, like Corfield versus Coryell, which Josh might talk about. It's an opinion in the 1820s from Justice Bushrod Washington. But it's a freestanding grant of rights, so we're not talking about incorporation, which itself is a constitutional malapropism.
Anachronism, if you will.
Yeah.
Because in many senses, if you were to go back to the 1870s and say incorporation, no one would know what you mean. This was really a term that the Supreme Court invented or introduced in the early 20th century. Now, that's not to say that incorporation is a fiction. We're just saying that the better route for incorporation is the Privileges or Immunities Clause. Just to elaborate on Ilya's point, the Corfield v. Coryell opinion is very interesting because it was this opinion by Justice Bushrod Washington, who was actually a nephew of George Washington. And while he was riding circuit in the Circuit Court of Pennsylvania, he wrote this opinion discussing the Privileges and Immunities Clause of the Article 4. And he wrote about these different protections, these rights which people hold.
You can follow along in your pocket constitutions.
Article 4, Section 1, Privileges and Immunities Clause.
Available at Cato. You get 2 for 1. You buy the Constitution, get the Declaration of Independence for free.
Or they can just get the free Federal Society
Or
Constitution.
actually, the Federal Society Constitution is right there.
Although I must admit that the Federal Society Constitutions lack a Declaration of Independence. I think that's inadequate.
That's a fatal flaw.
It's an epic failure. Anyway, so what the Corfield v. Coryell opinion did was that Justice Washington laid out all these different rights. Among them were the right to dispose of property, the right to contract. These are certain rights which people cannot be deprived of in a free government. And the radical Republicans heavily relied on Corfield's speech. The ode in Corfield to natural rights and to these basic fundamental liberties which we all hold. And this was one of the major persuasive evidences to determine what PRI meant. Now, I want to talk a little bit more about due process because...
Do you want to read the quote from Washington?
How about you read it?
Okay.
Yeah. You like it
Um,
so much.
I do. I think it's
So
important.
go for it.
Because basically Corfield v. Curry, the reason it's important, again, it's not binding, but because Senator Jacob Howard and Representative John Bingham were the prime movers of the 14th Amendment during the ratification process, during Reconstruction, they cited repeatedly to this, and here is what Justice Bushrod Washington, and again, his persuasive evidence isn't because he was the nephew of George Washington, just because, you know, he was interpreting what privileges and immunities are, which is very similar to privilege or immunities 40 years later. So, according to his opinion, privileges and immunities are things that, quote, are in their nature fundamental, which belong of right to citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union, including the following general heads: protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety. So it's basically natural rights as they were understood at the time, plus certain civil and political rights.
This echoes very largely the Declaration of Independence, and in many senses, while it's unclear what the Ninth Amendment actually protects for its unenumerated rights, it's actually it's a much more compelling argument that the Privileges and Immunities Clause protects a lot more unenumerated natural rights which we possess, just as nature being human beings. Now I want to talk a little bit more about due process. When I gave this talk yesterday at George Mason, I didn't talk much about due process because I was kind of hoping the Supreme Court would really like PRI. But after arguments this morning, you could tell that the justices were really focusing on due process. So I think
they wanted to see whether there were any weaknesses in Justice Thomas's position, because he, of course, doesn't speak out, and given that he already commands a majority position on the court, they wanted to see if there was anything that could sway them from that.
Well, Justice Thomas is definitely the
I'm
swing
being
vote.
facetious.
There's definitely the swing vote in this court, and they need to talk up to him. But I think that after today, I think it's a fairly safe assumption that we'll get 5 votes for due process incorporation. I think it's pretty good. You had Justice Scalia in a very interesting exchange discuss what will be easier. He asked, what will be easier? Do we do due process or do privileged immunities? And I think the answer, what's easier, would be due process. It's any second-year lawsuit could incorporate the due process clause. What I think
Any of you could write that opinion in your slate, assuming you take constitutional law.
Yeah, you only need Paul Clement to do that. So what I think that...
Would you say that again?
Nothing. Oh, it's recorded. You don't have to be Paul Clement to write a brief on how to incorporate the due process. Anyone can do it. So I think what you have to remember with this case, though, is that Justice Scalia, although he does not like substantive due process, he is afraid of opening the Pandora's box. And I think that might be underlying. In a recent opinion, in the Washington Post yesterday, he described the substantive due process as babble, but he described privileged immunities as flotsam.
So apparently in the Scalia rubric, a babble is worth more than flotsam. So where jetsam sets in, I'm not sure.
So the question becomes, is Justice Scalia willing to swallow his pride and restore the original meaning of a constitutional provision like the Privileged Immunities Clause, or does he want to take the safe route, stick with due process, and just stick with what he knows? I think that's really the question going forward. I think it's a pretty safe bet that we have Justice Thomas to perhaps use the Privileged Immunities Clause. I was also actually kind of relieved to hear Justice Kennedy. He asked a lot of questions today about the scope of unenumerated rights, what kind of rights are protected. Even if we didn't have the Second Amendment, would we still have this right to keep our arms? I think these questions speak to Justice Kennedy's interest in liberty and freedom and personal autonomy, which are very compelling interests in his mind, to read from his previous opinions. So I think it's very possible that Justice Kennedy might also be on board. And also Justice Ginsburg, she was kind of interesting, because she asked a number of times about the nature of these unenumerated rights. She asked, if we didn't have a Second Amendment, would we still have this underlying freedom to keep our arms? So while she dissented in Heller, I'm not quite sure where she's going with this. I don't really know what she's interested in, but Ilya, what do you think about Ginsburg? It's curious, her questions she asked.
Her questions were very feminist. She was very concerned that in 1868 or under the 1866 Civil Rights Act, the rights that were granted there, because the way that we understood at the time, that America understood at the time, rights granting provisions to apply, women, and especially married women, well, generally women passed from being under the control of their father to being under control of their husband, didn't have certain rights, just like certain other types of people didn't. And so she might think that for some reason that because of that, due process was a better protection for women than privileges or immunities might be. But I'm not sure, and whether that leads her to think that women might need guns because they're generally smaller and weaker than their assailants, and therefore, regardless of which theory she wants to incorporate under, she would strike the Chicago gun ban. I'm really not sure.
But Ilya, as we said, this case is not about guns, it's about liberty. And
Well, Josh,
going forward,
to us and to consistent, as Justice Scalia said, to the professoriate that wants to make Allen into a martyr for the cause or what have you, that perhaps might be the case. But as Justice Scalia said, we here are doing implied. I'm paraphrasing. We're dealing with the real law here, and we don't want to upset our centuries of jurisprudence. And
but Justice Ginsburg has been very active in arguing that much of our due process jurisprudence in the reproductive rights context is wrong. She's actually argued that equal protection would be a better right to get there.
That is
true. So if you look at Jack Balkin's article, Abortion Original Meaning, it's very possible that some of the more progressive justices would actually want to use PRI to get there. And that's a very interesting possibility that you actually have several of the justices on the left vote to strike down slaughterhouse, yet uphold the Chicago hunting ban.
On a kind of like a Breyer-esque balancing test of factors, yes, akin to what he did in Heller, saying that, yes, there might be a right, but it's balanced by all, there's an interest in the
Let's look at my favorite Breyer quote from today. You'll like this one. So, Justice Breyer asked the attorney for Chicago to quote, as you all know, the Due Process and Corporation Test asks whether liberty is, quote, implicit in the concept of ordered liberty. That's the test, from Powell, Connecticut. So Justice Breyer asked the attorney to make up an imaginary ordered liberty chart and give it to James Madison and see what he would do with it.
To which, was it Scalia or Roberts that said, it was Roberts that said, do you think that's the way that Madison went about doing his job?
No, but it's very interesting because that's the approach he wants to use.
That's the approach he wants to use, that's right. Well, that's the approach he always uses. It's always a Brandeis-free type of situation.
But this is new. He actually said that there can be shadow rights, and this was the point that John Paul Stevens and Breyer were saying, that if you're talking about the right to have a militia, then that's a high-level ordered liberty right. If you're talking about the right of self-defense to, quote, shoot burglars, that's a lower level. And what Stevens and Breyer were angling at is they actually want to give different protections to different kinds of rights to bear arms. For some reason, it's still hung up in the militia clause. I thought we got rid of that 2 years ago.
The problem there, though, Josh, is that Stevens is doing originalism at the wrong time.
He is.
Because the militia right, if anything, is tied to the founding. They were 1791. They were concerned about the British or this newfangled federal government from disarming the people and therefore not being able to counter its tyranny. In 1868, at the time of the promulgation of the 14th Amendment, and however you stand on incorporation, you're going to be using the 14th Amendment, the concerns of the framers and ratifiers of that amendment were much more violations by states against individuals, especially in the border and southern states, especially against freed slaves, and Unionists, in the gun context, disarming them, and also in all sorts of other contexts. So the militia rationale, whatever strength it had, as displayed in the Stevens dissent in Heller, kind of falls away when we're talking about incorporation.
It's really non sequitur. And I caught several of the justices making this error today where they kept talking about Madison and Jefferson. This isn't Madison, Jefferson. This is Bingham and Howard.
As much as we love them.
I love Madison. I love Madison and Lysander Spooner both. I think that I think that this is just a way to obfuscate the issue. They don't want to focus on the 14th Amendment. They don't want to focus on the liberty interest implied because it's such a broad, open issue. Now, one thing I want to focus on, though, that Scalia mentioned, and I think this is what he was angling at, is I think he wants to use a Washington v. Gluttsburg framework. He asked Attorney Gerst several times that rights that are, quote, deeply rooted in our nation's history and traditions. This is a Gluttsburg test. This is the most recent instantiation of a substantive due process framework. Scalia signed on to it, Thomas signed on to it, Kennedy signed on to it, there's also Rehnquist and O'Connor at the time. This is the test I think that Scalia would want to use. And this test asks whether a right is deeply rooted in our nation's history and traditions. And this is actually the test we propose in our article. We are going to very clearly, if you look at our history of our nation and how rights have been established for almost since time immemorial, the right to bear arms has been very deeply rooted, and it can be easily defined. Unlike the compassionate suicide issue in the Gluttsburg Test, having a handgun in your home to defend yourself against bad guys is pretty easy to do. You don't have to abstract too high of a general
Just to clarify, Washington versus Gluttsburg was a case from 1997 about the right to assisted suicide. And the court created a two-part test. First, how specifically you can define the right, the most specific level at which you can determine that this right has or has not been protected. And secondly, whether that particular right is deeply rooted in our nation's history and traditions. In that particular case, they found that the right to assisted suicide was not protected. But the more significant is the test that's set out.
And just one point going to that thing. Towards the end, during Gurur's rebuttal time, the chief asked if this would give judges more power. I think Alan gave the exact right answer. He said, this approach is deeply rooted in text and history. I mean, he's elucidating Gluttsburg. This is not some way to expand judges' power to pull rights out of thin air. Rather, this is going, it's a historical inquiry, not a metaphysical one. You're trying to figure out what are the rights that are deeply rooted in our history. And I think that, in this sense, privileges or immunities are actually more constrained than due process, because although the chief said something that due process is limited to process rights, that's not really totally accurate, because there have been so many substantive rights found in the due process clause over the past several decades, whereas privileges and immunities would only be substantive rights. But if you look at our article and follow what we say, it would be those rights that are only deeply rooted in the history of our nation. And I think that if the Supreme Court decides to go down the due process route, they will use Gluttsburg in one form or another. If you look at Judge O'Scanlan's opinion from the Ninth Circuit, and we have the attorney who argued, Nordike came to me back, say hello?
Derek Kilmer.
Yes, and we have a fully loaded classroom, as you can see. If you look at Judge O'Scanlan's opinion in the Ninth Circuit, he very adeptly used Gluttsburg, and he had a very easy way for the court to get there. All right, do we have any more observations on the case? I more or less went through the article, but maybe we can run through some
Yeah, I mean, just
today.
basically, what we didn't fully complete is that regardless under which theory you think incorporation or application of rights to the state should be done, the right to keep and bear arms passes. If you believe in the due process clause and substantive due process, which of course there are some substantive elements to due process, because you could have a kangaroo court, which is process, and you've done that, but it's a kangaroo court. So there has to be some substantive elements to it. But it's been warped beyond all original recognition because Slaughterhouse foreclosed the privileges and immunities clause. But even if, under due process, the right to keep and bear arms, under the Gluttsburg test, under the Palco test, Duncan, any type of test you want to apply that the Supreme Court has used, the right to keep and bear arms is so fundamental. The right to self-defense fundamentally is so fundamental that it passes. And under privileges or immunities, I think it's even easier because of as I said, the reasons for putting in the 14th Amendment and the PRI clause to prevent the disarmament of people who were against the prevailing political winds in the Civil War and post-Civil War era. And if you apply the Gluttsburg test, whether under substantive due process or PRI, the right to keep and bear arms is specifically defined as such, whether codified in the Second Amendment in 1791 or understood at common law before or after the Second Amendment. It's there, and it's deeply rooted, and it's not controversial at all, unlike other concerns that different people from different parts of the political spectrum might have. So that would be applied. As for the stare decisis issue I guess I should back up. The argument today, I don't know if the transcript, is this transcript out already?
Yeah.
I don't know how many of you, I don't know if anyone has skimmed that or anything, but the first question after Alan gave his introduction about how to be constitutionally faithful and simple and straightforward you would apply the Privileges or Immunities Clause. The first question by the Chief Justice was, well, you say it's so easy, but that would require us to overturn this 140-year-old precedent of the slaughterhouse cases. Bringing up the issue of stare decisis, of course, which came up in Citizens United and comes up in every
which
case.
the Chief Justice, joined by Justice Alito, a very interesting concurrence in Citizens United.
That's
And
right.
If you read his concurrence closely, it does counsel in favor of overturning Slaughterhouse.
Here's the thing. I mean, stare decisis is a prudential doctrine. There's nothing in the Constitution or any codified body of law about that you have to respect old decisions or something like this. It's an issue about reliance on the law being stable. You can't have the rule of law without being able to plan your business or personal affairs going forward. If you think the rules might change suddenly or arbitrarily or in whatever way. And so sometimes you do more harm, even if there's a decision on the books that's wrong, you do more harm by changing it than you do by leaving it and allowing people just to base it on that, by what they've relied on. Slaughterhouse, like the Austin versus Chamber of Commerce of Michigan case in precedent from Citizens United, but even more so, I don't think should have stare decisis effect. It should have the same stare decisis effect as like Plessy versus Ferguson. Because nobody relies on less liberty. Nobody relies on having an entire section of the Constitution read out fundamentally. And moreover, concerns that by suddenly having privileges or immunities being the governing doctrine for enumerated or unenumerated rights, there's a concern that doing that versus continuing substantive due process will somehow give judges more leeway. I don't think that concern is valid either, because as we've seen from our substantive due process jurisprudence, whether the issue be economic liberty, abortion, free speech, any type of right you might be concerned about, under substantive due process, the way the jurisprudence works is there's 9 black-robed philosopher kings go into a room and scratch their chins and say, well, is that fundamental enough? Is that a burden that's undue? Undue? Yes. No. There's not much principle there. It's not tied to the text, structure, and history of the Constitution. Privileges or immunities, on the other hand, would be tied, and to the extent that judges would, through sheer force of will, invoke their policy preferences, it would be, no worse than and potentially better than substantive due process.
In 1988, Justice Thomas, who was then not even a judge yet, wrote, "The natural rights and higher law arguments embodied in the Privileges or Immunities Clause are the best defense of liberty and of limited government. Moreover, without a recourse to a higher law, we ban our best defense of judicial review, a judiciary active in defending the Constitution, but judicious in its restraint and moderation." I think that's exactly what Ilya is talking about. The Privileges and Immunities doctrine is grounded both in history and our natural law tradition, which pervaded the Reconstruction Congress. This is a much more principled, historically accurate, in my mind, sensible method to locate rights than flipping a coin or going through footnote 4 of Caroline Products or saying fundamental, non-fundamental, intermediate, whatever.
Different levels of scrutiny, again, invented out of whole cloth by the jurisprudence.
And in most senses, the tiers of scrutiny is nothing but a reflection of whether the judges like that kind of right or don't.
Great article by Randy Barnett, a professor here, called Scrutiny Land in the Michigan Law Review a couple of years ago.
Right.
So coming back to the case today, to the argument today, I don't think the justices were buying what we are selling here, much of which Alan presented in his briefs. Thomas, of course, didn't speak. We were hoping that he might break his 4+ years of silence and say something, but Alan, I think you should have invoked cross-burning at some point to get him to speak. Justice Alito asked an interesting question regarding, a couple of justices were pressing Alan about which unenumerated rights were covered. Justice Alito said, would freedom of contract be included in that? Now, there are different ways to interpret that. My reading of it, and I was a couple rows in from the Supreme Court bar there, and I don't think he was hostile in asking that question. I don't think there was a specter of a stalking horse of Lochner in the negative sense. Some people like Lochner, some people don't. But in terms of economic liberties and things like that, I think he was probing from an honest intellectual perspective and might be amenable to that argument. So if anyone would be willing to join Justice Thomas in certainly the concurrence that he's likely to write, I think Alito is the most likely one. Now, Kennedy is an interesting case. Based on the way that the 4 liberal justices were conducting themselves, they're certainly hostile to gun rights. I don't know whether there might be some votes there for either substantive due process or privileges or immunities incorporation or application of the right to keep and bear arms, yet allowing under a Breyer-esque multi-factor balancing test, allowing the Chicago gun ban. I don't know if there's any votes for that, but because they seem to be reticent, I think Kennedy becomes the swing vote, both for which method you use and whether to allow the Chicago gun ban or not. And of course, Kennedy doesn't really apply either privileges or immunities or substantive due process. He applies the Kennedy, whatever I think is fundamental and sweet and inherent to the sweet mystery of life, and what I think is dignity and
It's
personhood.
interesting to note that in Law and Free Texas, Kennedy did not cite Gluttsburg once, even though that was the quintessential substitute process fundamental right case. He didn't even cite Gluttsburg.
I have an article in the latest Harvard Journal of Law and Public Policy called "The Sweet Mystery of Justice Anthony Kennedy." So I commend that to you. It's a book review. It's actually a long book review of a book that makes the what I think is audacious argument that Kennedy is libertarian, modestly so, in his jurisprudence. And my response to that is, well, yes, in certain areas, like free speech, especially in campaign finance, don't be fooled. He was not the swing vote in Citizens United. But he's bad in government structure and powers, and he's just weird and ugly in privacy and unenumerated rights, like abortion, and who knows what he'll do with this. It could be a splintered opinion in that way. I'll also note that Sotomayor just seems to misunderstand what incorporation is. Her first question, and her most substantive question, was framed out of a concern that all of a sudden, if we have incorporation, then states will have to have grand jury indictments and civil trial by juries and the very small bits of the Bill of Rights that haven't been incorporated yet. That's not the way that selective incorporation works. It's not the way that privileges or immunities application of rights would work. So, either I wasn't clear enough in Cato's brief, or
Do you think she read Cato's brief?
I don't know. I hope her clerks did. I don't know.
Wise move.
So we'll see what happens. But my prediction, realistically speaking, now going into this, I gave a presentation on this, or as part of a panel at Cato yesterday, and my kind of optimistic best case scenario was that we take for granted Thomas votes for privileges or immunities and strike down the Chicago gun ban. I was kind of hoping that the liberals would like privileges or immunities because of the brief of the Constitutional Accountability Center and all other serious progressive academics who like it for whatever reason, whether they have an agenda or not, but then allow the Chicago gun ban to stay in place for policy, Breyer-esque balancing test reasons. And then the other 4 would be afraid of polygamous, midget, heroin shooting, post office stuff, and would stay with substantive due process, but strike down the Chicago gun ban because it's so clearly enumerated in the Bill of Rights. And so you would have 5 for PRI, 5 to strike down the Chicago gun ban, and only Thomas overlapping those 2. I don't think that's realistic anymore. I think what we'll have is 5 votes to strike down the Chicago gun ban. So again, as I open this presentation, if you're cared about guns in the states, I think you're going to be okay. Although the third wave of litigation will be about concealed carry and the scope of other regulations. But Thomas again will stay alone, with Alito potentially joining his concurrence, and you'll likely have a Kennedy opinion for the majority, incorporating on Kennedy grounds the right to keep bear arms.
But as I rudely interjected, I think on no less than 3 occasions today, Justice Scalia mentioned that the concealed carry is not going to be protected by due process. I don't know why he said it. It wasn't an issue that was briefed. It wasn't an issue anywhere, but he made a point of saying that on numerous occasions. So stay tuned. I agree with Ilya. I think this is going to be a 5-4 with 1 vote for PRI. That's the thing. What I said yesterday didn't really change my mind, the arguments today. The only interesting vote will be Thomas and seeing how he chooses to do this. But
And
while
whether,
all this,
whether any of the other opinions are disparaging of PRI rather than just not reaching it.
right, but I think what's more important issue is not the issue today. What will the privilege or immunity case be in 5 years or 10 years, or say in the year 2020, for example? What's going to be the next big brouhaha? Liberals don't really like guns, but they like welfare. What if in a few years the Constitutional Accountability Center brings a suit saying that the Privilege and Immunities Clause protects a right to home and hearth, which includes a right of unemployment insurance, or a right of a Social Security, or a right of pick your close.
What about the right of the requirement that government provide you with a gun for self-defense?
I gotta consider that one. I don't know, but that's something food for thought. I don't think PRI is going anywhere. Even if we get nothing more than a Thomas concurrence, it'll plant the seeds. This Heller did not come out of nowhere.
So wait for our next article 20 years from now for the Constitution in 2040. And
Well, no, but think about it. Heller didn't come out of thin air. This was based on scholarship on the Second Amendment that had been started by the NRA and elsewhere for the past 20 years, from the 80s. This PRI scholarship is pretty new. I mean, the fact that Ilya and I wrote...
more by libertarian legal scholars than by the NRA.
Right.
Which pursued more of a
Right. I mean, the fact that we wrote one of the big articles on PRI, it says something. There's not much on there. There's not that much written about it. It's a pretty much of a blank slate, and that's not to demean Ilya, because he's a wonderful scholar, but this is a pretty wide open area. Going forward, you're going to see a lot more about this. If you do read the Constitution 2020 book, there's several articles, one by former professor, soon-to-be Judge Goodwin Liu, who actually argues that PRI protects a right to public education.
I was just nominated to the Ninth Circuit.
He was, yeah. So going forward, you're going to have to keep that in mind. I have nothing else. Do you have anything else?
Let's open it up to
Some
questions.
Some questions.
I was hoping you could expand a little bit more on this idea of the crack for PRI in whatever concurring opinion is going to come out of this case, that how that might work in the future in terms of some future case, because it would appear to me at first blush that if it's not now with this enumerated right that clearly exists, that whatever argument you could make for an unenumerated right, which might sound good on its face, that if it doesn't apply for the enumerated right, then how can it apply for the unenumerated right? So I'm curious how that plays out in the future, and if you have any thoughts on that.
So even though Slaughterhouse is wrong, that ship has sailed, as Scalia, the faint-hearted originalist, has said about all sorts of New Deal decisions, and now he might be inclined to apply that to Slaughterhouse. Right. Well, look at it this way. If it is indeed a 5-4 decision, but look at it if it's a 4-1-4, not in the optimistic scenario that I presented, but that there's 4 for substantive due process, incorporation, striking down, 4 saying it's just not incorporated, not a valid right, whatever, and Thomas provides the deciding vote under PRI. So there's not 5 votes for any theory, but it is applied or incorporated. And you might be in a kind of Bakke versus Powell situation with affirmative action in the University of California from 30 years ago, where that one lone opinion, even though there was no consensus by any 5 justices, becomes the de facto controlling one because it was the necessary one to form the court, to reach a decision. So that, in that scenario, if Thomas indeed joins the judgment but none of the substantive due process opinion, that could still salvage Slaughterhouse or PRI after all. But it really depends on how they end up writing their decision. And again, there could be one of the liberal justices kiboshing that analysis by joining the substantive due process and upholding or not the Chicago gun ban, because they could say, you could imagine Kennedy writing that opinion under substantive due process, and Stevens joining it, or probably not Breyer. Well, maybe Breyer. Yeah, Breyer. Breyer's most likely actually to join it and then say, but the Chicago ban survives for these public policy reasons. So he could do that, and then you would have 5 votes for substantive due process. And so the Chicago gun ban would fall, but the controlling jurisprudence would be substantive due process. So it really depends on how the vote turns out and what reasons each of the justices cite.
But going to your actual question, though, the distinction between enumerated and unenumerated rights, I don't think it makes a difference going forward. If in 10 years the Supreme Court made by President Obama has, 6 or 7 Democratic appointed judges, I see absolutely nothing stopping them from saying, well, the Second Amendment, the right to keep arms is not protected, but the right to social equality is. There will be no precedent stopping them because they're punting on this case. And that's one of the reasons why we said the originalists in the court should take the gauntlet in McDonald. You have at least 4 self-proclaimed originals. If you look at the Sotomayor's confirmation test, which says you apply the laws, it's written, blah, 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 that's originalism. So if they want to do what they said they're going to do, then this will be an opportunity to establish a jurisprudence rooted in history to prevent the perhaps future court from opening up the Pandora's box. Questions?
So everyone agrees? Or we were just very clear and you disagree vehemently, but there's no point.
Well, you kind of answered my question with his, but I was going to say, do you think it's going to be a plurality opinion, or do you think that Thomas will join and then write another concurrence saying, but it would have worked this way too?
I mean, Thomas is the most loose cannon.
In a positive sense.
No, in an absolutely positive sense, and he's principled. I mean, look at his dissent in Citizens United. He was the only one who dissented, saying no disclosure requirements. Go back to the last one in Nabudno, the voting rights case. He was the one who said, "I'm going to strike this down." He doesn't care. So
Look at his decision on Roush.
yeah, in Gonzales v. Raich.
Yeah.
Yeah, I mean, his decision in Gonzales v. Raich. I mean, he is the most principled justice, whether you like him or not. He is most committed to his principles. So I would not put it past him for him to splinter 414 and maybe strike down the ban and give PRI some legs. It's possible. It's very possible. There's a question here?
Oh,
And it's possible that not all of the justices have yet read our article, and so once they do so.
But rest assured, they all received a copy. Yes, sir.
Hey, I asked this at lunch, but it's such a good answer, I'd like to hear it again. Why is the Privileges or Immunities Clause question even there and the question presented if there's such generalized hostility to it?
Part of the reason is that Alan's brief was so much better than the NRA's. Now again, this is before they hired Paul Clement. It was I don't want to get into right now why they hired Paul Clement and why they filed a motion for divided argument, but that's kind of a controversial issue that separates the gun nuts from the Constitution nuts, as it were. But Alan's brief was better, and maybe they have some antagonism against the NRA. They don't want them necessarily presenting the argument. They think somebody's more objective about the right to keep bear arms or the right to self-defense.
It's also a possible standing issue because the NRA is a corporation and McDonald's individual, and that's
right.
That's also an easy answer.
Yeah.
But I think on an even deeper level, Alan, you got it?
Yeah, well, I don't want to go into the psyche of the court and into why they did it or why they didn't. I have my own theories and they'll remain private. But one thing I do want to make clear, and I make it clear to everybody, is that none of this was a surprise because the city of Chicago in their brief in opposition, and all this, by the way, is on our website, chicagoguncase.com. You can read everything there. Their brief in opposition said, please take the due process question. Do not take privileges or immunities. You don't need to go there. Slaughterhouse is great. It's old. Leave it alone. Move along, nothing to see. And so we responded with a reply saying, no, no. We even had a heading that said, I think the heading is, slaughterhouse must be overruled. And so nothing here was a surprise to the court. They knew what we were going to argue. We made it very plain, especially on reply to the cert petition, we felt that this was going to be the better approach, that it had to happen, and it was over and actually an objection from the respondent. So, whatever else the court might have been thinking, it should not have been at least surprised by the argument. And as for why they do what they do, I mean, I don't know. I got asked a question the other day, why didn't they release the tape of the oral argument? I don't know. I have no idea.
Because one of them objected, because they had a cold today. I mean, that's a good enough reason.
I mean, a lot of times the courts are inscrutable, and if there's one thing I've learned practicing all over the years is that, it's a great parlor game to try to second guess the mind of a court or a jury, but ultimately they just, they do these things and then you deal with them. So all I can say, at least for my part, is we briefed it very clearly. We made it very, very, very obvious that this is where we were going, and there were no surprises. So it was, why they did it, who knows?
I think there's a question right here.
Yeah, one of the things that struck me, I got a chance to get in today, is that the court and Chicago mainly were stuck in the 1790s in terms of the founding era and yet the case was really about the framing era in the 1860s. And the other thing that struck me as odd is the sudden urge to talk about, by Justice Breyer, people parading around with guns, and the city of Chicago suddenly afraid about open carry. Don't you think a carry case might have to come back and analyze that right in the framing area, the Dred Scott through, I got to travel through Klan country problem, and could there be another shot for PRI in a gun nut case?
It's very possible. The issue of the carry is not an issue in this case. All that's an issue in this case is simply whether the person own a firearm in his home for purposes of self-defense. I have no doubt that at some point in the future there will be litigation regarding the concealed carry.
Although it couldn't be interpreted in a gun nut case if the PRI isn't opened up in this case.
I'm not even sure you can get, even if it's not PRI, you can probably get government due process. I mean, I don't think
If they apply the same standard.
Yeah, I mean, what if someone brings a suit in the District of Columbia, theoretically, for challenging a concealed carry? I'm pretty sure in DC you can't get a concealed carry permit. I'm sure they would just do it under the Second Amendment. I mean, the word bear is in the Second Amendment. I'm sure they can figure something out with that.
So for all future gun regulation, every litigator will know that you first challenge it in DC, and then your next suit is immediately in the States. Alan?
Well, just to follow up on that, there is actually a lawsuit about that. It's one I'm currently representing, Palmer versus DC. And concealed carry, the word concealed has been glued to carry in a way that's not really useful to the debate. And I guess it's because concealed carry is so popular these days, and it just kind of rolls off the tongue. But that's not actually what the law looks like. If you go back to Heller and 19th century precedent, Heller cited no fewer than 4 cases from the 19th century that struck down bans on carrying firearms in public. And the distinction in the 19th century was that you could ban outright concealed carry because only dastardly sneaky people were going to be concealing their arms, and you could, of course, not have government ban open carrying. And the way that courts eventually understood this was to mean that the government can regulate the manner in which you're carrying, so they can prescribe either open or concealed. They simply cannot ban both. And then you have other language in Heller that says, well, you can't carry a gun in sensitive places. Well, that means in non-sensitive places you can carry a gun. And there's talk about you can't have any type of gun anywhere for any purpose. Well, that sounds like time, place, and manner. Presumably you can have it some places, sometimes for some purposes. And so D.C., which is the only jurisdiction other than Illinois, has absolutely zero carrying whatsoever of any kind. And that's why they got sued, and hopefully they'll lose. Obviously expecting to say that it's my case. But
where is it procedurally right now?
Procedurally, we have cross motions for summary judgment. The case has been argued January. It's already March. And we'll see what happens in district court. And the relief we're seeking is very simple. We're not telling D.C. how to regulate the carrying of guns. We're simply saying they can't ban it entirely, completely. And so they must devise some system where they, address this in a respectable constitutional manner and go forward. And we have cases also in states where they have a regime, but the licensing is arbitrary, discriminatory, etc.
And the lead plaintiff in that case, Tom Palmer, is my colleague at Cato, who 25 some odd years ago, his life was saved because walking around in San Jose, he was accosted by a gang of homophobes. He happens to be gay, who said that they were going to kill him until he kind of lifted his jacket and showed that he was carrying. He was one of the plaintiffs in the original Parker case, which became Heller, but there were 5 plaintiffs there that were dismissed on standing grounds. So there's Alan, like in this McDonald case, Alan has a knack of finding strategically plaintiffs that are not, it's not felon in possession or somebody that's unsavory that's trying to get off of, on a technicality from some prison term or something. These are law-abiding folks who want to live their lives and protect themselves from the violations of their rights. What's that?
From burglars.
That's right.
Just
Burglars, assaulters, rapists, all the rest of it.
Just one, I can actually tie this into arguments today. One of the topics that came up over and over again
was that the city of Chicago argued that their handgun ban was a, quote, reasonable regulation. Well, it's a ban. You can't have it. They said, well, you can have long guns, but not short guns.
If that's reasonable, then there's nothing that's unreasonable.
Right, and I think that would be the argument that Alan Gore, I assume, would make, that you can't have a reasonable regulation that bans an activity outright. You can disagree on gradation, so maybe you can have a concealed carry permit with different training or such.
Because that's the other thing about the McDonald case. Unlike Heller, none of the briefing was about the Chicago gun ban itself at the Supreme Court. So, regardless of what they do, it's a safe prediction to say that they'll remand for further consideration of the Chicago gun ban in light of what they decide.
Judge Eastbrook correctly opinion you want to write
That's right.
in McDonald, or NRA of Chicago is his term. Questions? Sir?
Assuming that the majority opinion does effectively decline to really squarely address the POI issue, but assuming that one day down the road in the near future they do grant cert to a case where that's the sole issue, do you think the ideal circumstances procedurally would come in the form of a circuit split where the Fifth Circuit does incorporate POI and, say, the Ninth Circuit does not, or vice versa?
Well, the problem is, I don't think any...
No circuit can because of Slaughterhouse.
They don't have the chutzpah to do it.
They can't overturn Slaughterhouse.
Yeah, I mean...
Even...
Well, Scanlon, tried to kind of overturn Crookshank.
Crookshank by substitute process, not by a PRI, yeah. Although I will put in a plug for the Fifth Circuit where I clerked, in that before Heller, that was the only jurisdiction where you had the right to carry both arms and sex toys, which opened up a circuit split with the 11th Circuit. So I'm looking forward to the right to bear dildos case coming out.
All right.
That's what they called it, though. The name of this Texas statute is?
The right to bear dildos?
No, it's the Anti-Dildo Act.
Oh.
That's the name of it.
There you go.
It's been a
So I think they're looking for a
Really
plaintiff
long
lawyer
day.
down there, Alan. That might be your next
You know,
area.
it's interesting, there was an argument in Heller that some very smart law professors filed that guns are simply items of personal property, and personal property is not entitled to any kind of protection, and of course we would then get reliable devices, whatever they call that case in the circuit.
Yeah, that's right.
So,
And my judge, that was the first time he was ever wrong on any issue. He was on the wrong side of that en banc decision. In the Fifth Circuit. Not to take it.
not to be,
That's right.
I think it was correct.
I think that's correct. They're reliable devices.
Yeah.
Anyway,
Put it back.
it's good.
Josh just wrote, that's what she said.
Take it. All right, in the back.
Are various key leaves to be read from the felon in possession opinion that Scalia read this morning?
I don't have my notes.
No, that was the Armed Career Criminal Act and whether an act of force, and if anyone's ever clerked here is going to be, this ties up the docs about whether something's an act of violence or force or whatever. That had nothing to do with the guns. That had something to do with whether touching somebody or what he was convicted for was sufficient force to qualify as a sentencing enhancement under the Armed Career Criminals Act.
Did anyone see the Alito Thomas dissent? I've been running, I haven't had time to read it. Usually when Thomas can say, did anyone read it? Anyone want to share? Oh, come on, your law student.